he is limited by the provisions of the Constitution. He cannot go outside the Constitution and do something unconstitutional. So, yes, he's a president, but the law controls him. Then, if you go to Article 93(2), we are told that Parliament, subject to the provisions of the Constitution, reserves the right, has the authority to actually exercise the legislative power of Ghana. In other words, the lawmaking power of Ghana is vested in Parliament. And then also, if you go to Article 125 of the Constitution, we're told that the judiciary is responsible for, exacting justice for and on behalf of the good people of this country. Now, what we must derive from these provisions is that none of the arms of government is above the law. So that any time, as I stated earlier, they act contrary to the provisions of the Constitution, they can be whipped back into line. And it is the Supreme Court that has the authority, generally, to do that. So what happened in this particular case? There was COVID. Everybody was panicking. The world leaders were responding with all kinds of measures. In Ghana, we thought that, yes, we should equally respond. It was something that nobody, had experienced before, at least in recent memory. So the president thought that, okay, let me engage, Article 21 of the Constitution, which guarantees specific, rights for Ghanaians. So, for instance, the right to go and worship wherever you want to go and worship, the right to, freely associate with whichever group you want to associate with, issues about freedom of movement and all of that. Those are contained under Article 21 of the Constitution. But there are some other provisions under the Constitution, for instance, under Article 31 of the Constitution, which grant emergency powers to the president to impose state of emergency, where he considers that, for instance, maybe Boko is a bit troublesome, so let's impose a state of emergency. But what happens is that when you make such a determination in consultation or on the advice of the Council of State, what happens is that you must quickly send the declaration so made and the facts supporting it to Parliament, because Parliament is to review the order that you have made and decide whether or not, through a resolution, they approve it. For some reason, the president and his men thought that the framers of the Constitution perhaps intended something different. So they went under Article 21 of the Constitution and invited Parliament to pass the Imposition of Restrictions Act of 2020, which was to empower the president to do the things that were done. You can't go to funerals, or even where you were going, you were limited in terms of the number of people attending. Church ceremonies were basically, stopped at some point. But then even when they resumed, they confined the numbers and all of that. And the Parliament of our Republic also granted the president the authority to extend as and when he thought it was necessary.
But was it not for the betterment of all of us at that time?
You see, the problem with what both the Parliament and the president did was that the framers of the Constitution had already laid in stone under Article 31 what should happen under circumstances like that. And subsequently, Parliament, in its own wisdom, implemented Article 31 of the Constitution by passing the Emergency Powers Act of the Republic, which basically implemented the provisions of Article 31. So the president needn't ask Parliament to do what it did. And the Parliament of the Republic also ought to have known that they were acting unconstitutionally. But for some reason, despite the dissent that some, MPs, advertise, and members of civil society organizations raise objections, Parliament went ahead to pass this act. And on the authority of that act, a number of things happened. People could not properly bury their parents. People could not properly mourn their loved ones. People could not practice the way they wanted to. The people in the Volta region who wanted to go to church, they were confined. The people who wanted to go and worship. No, I'm speaking for my people. The people who want to go and worship Mauga Subolisa, they were restrained from doing that because the president so thought that he was acting lawfully. Somehow, dutiful citizens of the Republic, both natural and unnatural, went to the Supreme Court in keeping with Article 2 and Article 130 of the Constitution and a definite pronouncement has been made, the law has been struck down as unconstitutional. So the entirety of the law is no longer going to be on our statutes.
Okay, Salam, I mean,
Well,
what can we do with this?
Yeah, so I think it was quite unnecessary. I mean, this imposition of Restrictions Act, because Act 472, which is the Emergency Powers Act of 1994, had already provided for things like this, taking its source from Article 31, Oscar has elaborated on, of the Constitution, which deals essentially with the emergency powers. So, it didn't make sense that this had to come, but the president did it anyway, and because of the situation at the time, the fear of the unknown, I mean, etc., a lot of people just kept quiet and made it go through, even though a few people raised issues. But those issues people were raising, the generality of the populace were not looking to debating those issues, or were not looking to having those issues addressed, because we were seeing the pictures on TV, people dying all over the place across the world, and we were told that this was in our interest. But you see, the laws are there for a reason. The president is the president, he's the boss, but the law is actually the boss. The law is what regulates everybody. That's why we say nobody is above the law. If the president is given so much power, executive power, those powers are not to be left just like that. Those powers must have a lid on them in what we call constitutionalism, a lid on them, so those powers are not abused. Those powers are checked by other provisions of the Constitution. So, for example, the Office of the Auditor General, for instance, it's one of those offices to check that power. A number of provisions in the Constitution ensures that the president does not act the way he wants. So in this case, there's an elaborate provision in Article 31, which deals with how to invoke emergency powers if there is an emergency. And what will an emergency be? A natural disaster, or something that something that poses danger to society. It could be anything. But once the president is convinced, with the advice of the Council of State, that this is one of those circumstances or situations, and those circumstances have been spelled out in the Constitution, 31(9) or so, deals with all of that. With the advice of the Council of State, it must be gazetted immediately, taken to Parliament. Parliament will deliberate upon it, pass a resolution, and do all of that. Then we can start, implementing the law, as it were. And even the law tells us that it must cease, or the state of emergency must cease after 7 days, unless it is extended by a majority of members of Parliament. It is done so because, when you are doing the law, when you're enacting law, you don't enact the law thinking that we'll forever have good presidents. There could be a time that we'll have a bad president who wants to do something, and because he has the power, he can use the power to do as he pleases. So those things are there to discourage the abuse of power that way. So now we have, Article 21, for example, under Chapter 5 of the Constitution, generally deals with, rights, very, very important rights. So this particular law, the long title of the law is what? An act to provide for the imposition of restrictions in accordance with paragraphs C, D, E of Clause 4 of Article 21. So Clause C is freedom to practice any religion and to manifest such practice. D, freedom of assembly, including freedom to take part in processions and demonstrations. E, freedom of association, which shall include freedom to form or join trade unions, blah, blah, blah. These freedoms, by this act, were suspended. So you couldn't even go to church. You couldn't go to school. You couldn't go anywhere because of a certain coronavirus. It may be well intended, but the Constitution had already provided a way you do. So you don't go, you don't go enacting parallel structures. That is wrong. And that's what the Supreme Court has said it's unconstitutional.
But the president may have been guided by something to go and do the parallel thing, no?
Guided by who?
The law is your guide, and the law provides elaborately. And the
president from the law,
and he ought to have known that this is provided for in the Constitution. So he hasn't told us why he decided to depart from it to do this. You understand? So the Supreme Court, I don't know why. Maybe the two decisions were made on the same day. I don't know how it happened, but exercising what we actually expect of them. This is a typical case of judicial review. Parliament enacts a law, somebody brings it up under Article 1221 of the Constitution, that this doesn't pass the test. This is inconsistent with the basic law, and so ought to be declared null and void. And Parliament, judiciary, or the Supreme Court actually looks at it and says, no, this is true. This is inconsistent with the law. So we declare this unconstitutional. It is not the first time the Supreme Court has done this. Supreme Court does this quite often. One of the very recent ones is the matter of the bail. Interestingly, Martin Pebu was in the Dominovo case. I think he was the lawyer who argued. He was a lawyer for the plaintiffs, and big congrats to him. The same person went to court to declare one of the is it 96 or 97 part of it of the
matter.
No, not the will matter, the non-bailable offense
okay,
bit.
okay.
The fact that once you are arrested for certain offenses, you cannot be granted bail until the matter is
narcotics
done.
related.
That was, and that law was passed out of emotions in 2008 or so, where there were a lot of cocaine matters. You know, a specific part of that law for narcotics. In fact, narcotics was added to that if you are arrested for a narcotics-related matter, you cannot be granted bail. So I can be passing somebody say, no, this guy has weed in his pocket, or I mean, and they fix something, and they find weed on you, and that's it. You will be in custody till the matter is dealt with. And the way our courts run slowly. And if you are this murder charge, you cannot be billed, etc. Those were restrictions on the liberty of the people. Yeah. And the man is presumed innocent until he's guilty. So you would have kept the man in custody for a very long time. In the end, he may come out victorious, or he may be acquitted and discharged. What have you done to him? So Pebu and Co went to court to say, no, this law, is inconsistent with the Constitution. The Supreme Court, in exercising that jurisdiction, struck it down and declared it null and void. So it does a lot of those things, and it has the power to do a lot of those things. We expect them to do more. But it's also unfortunate, once again, that the decision has come, how many years? 2-3 years after the law was enacted. Yeah. Interestingly, 2 weeks or 3 weeks ago, the WHO declared that COVID was no more a pandemic or an emergency disease. The president last Sunday also declared that COVID was no more a pandemic in Ghana. Yeah. And Wednesday or Tuesday, the Supreme Court now comes to say that this law is unconstitutional. Interestingly, for over 2 years, the Supreme Court is now telling us that, yes, the decision has been made, but the reasons will be made later, will be given later. Yeah. Why? What if you're not ready with the reasons? Why then come and tell us? Because we'll be waiting forever. Yeah. So waiting for 2 weeks extra to give us the reasons with the judgment on the day of the judgment wouldn't have. After all, the thing was no more an emergency.
But why do the reasons always delay? What's with that?
I don't know about always. It's not the case that it.
Most of the time.
Well, I don't know about most.
Especially if it's of public interest.
Frequently. I would use the word frequently.
Be careful in your choice of words.
You see, I mean, with my background in the UK, when matters like that are to be decided by the Supreme Court, they do everything. They come to the courtroom and they read the judgment. They read it, and by the time they finish, it is on their website, and they even have a press brief. So there's a press statement that is issued, briefing the judgment to about, say, 3 pages for journalists, so that they can go and inform the good people of the UK and the world for that matter. I think that we should learn from best practice. Of course, it is not in all cases that UK courts will sometimes give their judgment the same day and provide the reasons. I mean, when the situation requires, they will create an exception. But it is an exception rather than the norm. In our case, I think people are arguing based on what has happened traditionally in our courts, that it seems to have become the norm rather than the exception. With the greatest respect to the justices of our Supreme Court, I think we have to pick up the pace and see how we can deal with these matters. Judgment read the same day, made available to the registry, circulated on the Judicial Services website, and the good people of Ghana become, because people must know the law so that they can act accordingly.
So based on the ruling, people who were affected by the president's decision at the time, which is all of us, can we go back and do something?
Well,
in terms of the courts?
No, at the time I mean, it was law. I mean, and at the time, it was law, and laws are made, changed, repealed, etc. If it's that way, people may go back and say, okay, at the time you punished me for this, this was the law, and now the law is no more, so I need some remedy. It doesn't work like if it works that way. There'll be a lot of chaos in the system.
So done,
what is
that's
gone?
it.
But I depart from that.
What is gone is actually gone, because at the time you were punished, that was law. Whether it was good law or not.
But in this case,
depart
it
from
was
that
it was against
Yeah, I think it
the
was
laws.
unconstitutional.
Yeah.
Yes, but
this- for this
but,
matter.
but at the time, you know, you went to I don't know whether anybody was convicted or not under this.
Okay.
But at the time, the operative law, the constitution is there, but the law you would have been charged under, or the law which would have been the operative law, was this. You understand? Unless, of course, somebody argued that this is the constitution, this is what the constitution has said. If it were that clear, I'm not sure anybody would have gone to the Supreme Court. So the general principle or rule is that at the time this was the law. Of course, I understand the argument about the constitution.
Yeah.
At the time this was the law. Until that law is repealed or that law is struck down, that is the law. And everything done under that law remains the way it is. That's generally the position.
Well, I depart from the view, with the greatest respect to my colleague. I mean, I take the view that it has always been the law that act was unconstitutional. What happened was a mere declaration by the Supreme Court that, look, what Parliament and the President combined to do, because the President caused them to pass it, they passed it, he assented to it. And then on the authority of that act, also issued an executive instrument, which formed the basis for many of the things that they did. And what they did was unconstitutional. I think if people are so minded and someone feels so aggrieved by reason of something that was done under the authority of that act, if they are so properly advised, they may want to, test.
Would you advise a client?
No, I would not.
You wouldn't touch
the
the
law of our practice doesn't what do you call it? Doesn't allow me to advise publicly like that. Ask somebody I can't do that. I'm just saying that if the person so,
Okay.
mind,
so you advise in chambers, not publicly.
He would act accordingly.
I will see you in chambers that So you can send your messages, quite a number that have come in. The number is 020-444-7033, 020-444-7033. This one says, Domlevo is a hero, posterity is the best judge. Another one says, I really enjoy watching your program, and it's unfortunate that it's only on Thursdays. Kudos to Team City for always giving us quality programs. I'm Nana from Pokwase. This one says the two cases are not the same. In the case of the Auditor General, who was fired by Atamils, his retirement age was far above the retirement age. That particular man was 63 years, you say. And then this one says, so did the country suffer any loss for the illegal directive by President Kufuor at the court? That's a question you asked. So,
I mean, the issue is that I think one of the cases, the Supreme Court said that they were not making any consequential orders. Okay. So ideally, I've not seen the reliefs properly so-called. So ideally, the Supreme Court would have made consequential orders if it was relevant. I think it was the COVID one that they said they were not making consequential orders. In the case of the double level, they said that the matter had become moot, so they were not going to make specific grant specific reliefs in connection with what they whether he should be brought back to office and all of that. So maybe that will settle the issue of whether somebody can go back but it could be tested if somebody so.
Okay. Yeah. We'll see whether we'll see anything like that. So those are the two court cases done there. If we have a few minutes, maybe we can go quickly into the road infrastructure, if that is okay with you guys.
You, the people of Teshi.
We, the people of
That's why
Teshi.
you are still in your red. It's a red event.
We are not happy, Salom. Our roads are bad. Our
Yes.
inner roads are bad. I mean, I can't use the inner roads, to
Okay,
go
I think
to
Salom
town.
should interview you. At
Yes,
this
he
point.
has to. He has to interview me for big issue. Book me for big issue. And Sky, book me for breakfast show.
Yeah, that's right.
But essentially, we saw the residents of Teshi, hit the streets early this week protesting against the inner road. Subsequently, authorities have told us they are going to fix that road. But I mean, should we be always you know, fighting to get the things that we are supposed to get done for us.
I think it's unfortunate that we have a situation where almost everywhere in this country, roads are in terrible shape. Of course, I mean, there are some good roads around, but we've not been repairing roads for some time now because of the difficulties we have with funding. New roads have been constructed in some areas, some alphatic relaying done in some areas. But the fact is, many roads are actually suffering. And if you remember, the president, when he became president at the Independence Square, said that we should engage as citizens. We should not just simply sit down on the fence and then, you know, watch. We should engage, offer constructive criticism and all that. So I think that what you did in Teshie, you know, was in keeping with that presidential, you know, edict sent out to Ghanaians that, look, when things are not going well, you should be bold enough to criticize. And then also the point is that, look, people pay taxes. When they pay their taxes, the expectation, which is legitimate, is that government will provide them the services that would represent a certain compensation for the taxes that they have given to the government. For some reason, many things are going bad. In some cases, the resources are not used the way they ought to have been used. So it was legitimate that the people of Teshie and surrounding communities went onto the streets to demonstrate. They are showing that as a citizen, you do not have to sit down when things are going bad. You should sit up, speak up, and insist that the right things be done for your benefit and the benefit of others. And kudos to you.
We'll continue to demand till the roads are fixed.
Exactly.
We are not leaving it.
Yes,
We don't want patch roads.
Yeah, so I think central government has a role, but when it comes to certain aspects of the community, I think the district assembly or the municipal assemblies also must be alive to their responsibilities. I think some time ago there was this, I don't know whether it was a directive or something a lot of the district assemblies did. They had graders. So if a particular community had difficulties, they went there to grade the roads. I think that helped quite a bit. And, you know, this practice where we leave potholes to degenerate, to become wider and bigger and become manholes, I think must be discouraged. When potholes are developing on the roads, it's cheaper to repair them or to fill those potholes. It makes the roads last longer. It relieves the users of the road the burden of having to be visiting the mechanic shop, etc. Because the roads are bad and they are part, but their car parts to be damaged or are damaged. I mean, the district assemblies must be alive to their jobs. Roads that are within their purview, they should do what they can do to be repairing those. The issue about it. So that's why I was happy when I heard that the MP for Adenta, for example, used his car loan to buy a grader. I mean, that's a personal sacrifice. District assemblies, with all the money they get and things like that, should be able to invest in graders. If a district assembly has one grader or two, I think it will do a lot to help. So now it's raining. A lot of the roads in the communities which are not tarred, but are used heavily by people or by cars, they can be graded every now and then to ensure that the potholes and the wells on the road do not develop beyond a certain point. And I'm sure when they do so, the people in the community will know they are trying their best. Everybody knows that government cannot do the roads for everybody at the same time. But we must see government contributing, government, you know, showing concern, you know, empathizing with the people and trying to do something rather than leaving people to demonstrate before you move on the road. It is not the way to go. And government cannot accommodate it if we have these demonstrations across the country. I mean, government will shut down. And I think they must think properly and then be proactive in resolving some of these issues, because we all need roads.
Okay. Some other quick messages. This one says, good evening, nice intellectual debate ongoing. Greetings to Dela, Salom and the entire team. This one said, what did the Supreme Court say about the act with regards to the people who suffered any form of loss due to the illegality of the president's action? We're all waiting for.
But like I said, I think under that particular one, they said they were not going to give any consequential orders and all of that, which is to say that.
Done and dusted. Move on.
Yeah, but like I said, if someone is so minded, they know what to do.
Okay, so gentlemen.
So usually, I mean, if it means it never existed. I mean, it never happened. You know, so maybe if if your record should be dented by virtue of a wrong you might have committed, my thinking perhaps is that that wrong never existed, because that wrong might have been committed under a bad law or something.
Okay.
I mean, declaring it unconstitutional means that it was not correct or right from the beginning, so maybe it never existed.
Okay. Thank you very much, gentlemen, helping us to understand the two cases, Richard Sky and Stella Madono. Thank you so much. My name is Vivian Kailoko. Thank you so much also for joining us. We'll see you again next week. Goodbye.